In 2024, the National Institute of Justice was one of many federal agencies that asked computer scientists and the entire public for information about the responsible use of AI in the federal government. The goal of using AI is to try to be more objective, more accurate, more evidence-based, to try to get away from the personal biases, conscious or unconscious, that humans have. The question is, can we tell whether these tools are performing that way? How can we tell whether they are in fact accurate and fair? So I think in the justice system, there are two kinds of risks. One is the one that we've heard a lot about, that a tool might be less accurate or it might overestimate the risks for people who are people of color or low-income people. The greater challenge in the justice system, though, is that statistical fairness and accuracy are not the only things we care about. We care about procedural fairness. So in our Bill of Rights, we want a defendant to be able to confront their accuser. We want them to be able to cross-examine witnesses and contest evidence against them. That is much harder to mathematize, and I think what we argue in this piece is that in order to meet those goals of procedural fairness, any AI tools used in the courtroom have to be very transparent. You need to be able to explain to the defendant what data about them was used, why, detention was recommended or why a certain sentence was recommended, because they have the right to argue with it and to contest it. It's important not to have one national study of an algorithm and then say, we're one and done, it's accurate, it's fair. People in this field have found over and over again that algorithms which work very well on a training data set that is collected from jurisdictions all over the country don't necessarily work that well in a particular place and time. And this is why professional associations in law enforcement and in court administration argue for periodic local revalidations of these studies. I think it's very important for judges to understand the strengths and weaknesses of these AI systems. So for instance, these risk assessments by design are only based on things like your past convictions, in some cases your past arrests. They don't know your social media. They also don't know that you were convicted a long time ago, but since then you've turned your life around and now you're in culinary school and you've proved to be a valuable member of society. They don't know these things. The judges should understand that a risk score delivered by an algorithm is really just an average amount of risk for defendants with similar criminal records. The other thing we say in this article is that verbal labels or categories, like calling someone high risk, are not as good as giving the judge a clear, falsifiable, quantitative statement like the average chance that a defendant with this kind of criminal record will be rearrested during the pretrial period is 7%, or something like that. And for that matter, it would help to know rearrested for what? Are we talking about risk of being arrested for a petty misdemeanor, for trespassing, or for an attempted homicide? The good thing about AI is that we can measure it. The good thing about it, if it is transparent, is that we can tell what data it uses and figure out what that data tells us. And the good thing about it is, unlike human thought processes, AI, if it is transparent, can be explained. So bringing in transparent, explainable, interpretable AI into the justice system really could make the system more accurate and more fair. Bringing in proprietary, opaque systems into the justice system will not do that, and has the danger of burying a lot of unfairness under the rug, under a thin veneer of objectivity.